Thank you to the Center for Animal Law Studies for giving us this opportunity to talk today about the rights of nature. What we want to talk about is the sort of growing movement around rights of nature, and specifically what it means or could mean for wild animal protection, and why globally we here at the Global Law Alliance for Animals and the Environment at Lewis and Clark Law School think it's a legal effort with promise, from both a sort of principled perspective as well as from practical perspectives. And my colleague Nick Fromherz and I will sort of walk through here what we think both of those sort of how the principles around rights of nature can be helpful to both animal law and environmental law, and then what it means in terms of the practical upshots of wild animals, in particular, being considered as rights holders under a rights of nature framework. So to get started, one of the things that we need to think about is sort of how are wild animals being impacted by human behavior? So when we talk about living in the Anthropocene, we're talking about living in a world significantly influenced by human behavior. That's the primary characteristic of sort of the era we're living in now. It's a non-geological era, but we use this phrase Anthropocene to talk about the fact that human behavior is changing the world at a rate beyond what would be sort of a baseline rate without human interaction with the world. The growth in human population, coupled with economic growth, technological growth, and the consumption that fuels all of that growth, at the end of the day, is leaving no part of our world untouched by humans, whether those impacts that we're having are direct or indirect. And this report, published just a few years ago, produced by the Intergovernmental Panel on Biodiversity and Ecosystem Services, or IPBES, as some folks call it, really made this point, I think, crystal clear for those of us that work in the wildlife space, by stating in no uncertain terms that we are in the midst of an extinction crisis, that there is this biodiversity crisis ongoing, and that humans are largely the cause of it. So some statistics that are just kind of jarring but helpful to think about: of an estimated 8 million animal and plant species worldwide, 1 million are now considered to be threatened with extinction. And so more than 40% of amphibian species, almost a third of reef-forming corals, sharks and shark relatives, and over a third of marine mammals are threatened with extinction within that 1 million species. So there's a huge impact that we are having on wild animals. And we're talking here about species extinctions, but it translates to individual animal suffering as well. And I think one of the things that drives that home the most in terms of this report is that the greatest driver of biodiversity loss, as it's framed in the report, but also suffering by wild animals, is habitat destruction and degradation, with direct exploitation for terrestrial and freshwater species being the second greatest driver, and in fact the greatest driver in the marine biodiversity context. So what we're really talking about here are both direct killings of animals, as well as direct and indirect harms. And like I mentioned, from an animal law perspective, there's concern, right, that these reports and the data and information is always sort of focused around biodiversity, and extinction risk, which is a function of sort of the rate of reproductivity. But I think from a practical perspective, it also just means that individual animals are losing their lives and struggling to fully express themselves as sentient beings with needs, including these basic survival needs of food and habitat, but then also the related needs to enjoy freedom of movement, of play, of reproduction, of physical and psychological integrity, and of general health and well-being. So I think for me and for Nick, one of the things that we take away from this report, in addition to sort of all of the alarm bells that go off from a sort of broader, maybe more environmental perspective, is that really there's this strong link between protecting wild animals and individual wild animals and taking care of them, and our our behaviors that are causing habitat loss and deterioration around the world. An alarming statistic is that global terrestrial habitat integrity has been reduced by 30% relative to an unimpacted baseline. So like all these animals that you see here on the slide, they all depend like wholly and integrally on having the right kind of habitat that they need to meet their needs. For humans, it's really different, right? Like we build our environments in large part, and we just continue to build and construct new environments to meet our ongoing needs. And for non-human animals, right, like it's a very different way of engaging with their environment. And obviously, we're the ones in control of what their environment looks like. So, direct exploitation, whether for sport or display or food or otherwise, the direct taking of animals has always been front and center in the animal welfare and animal rights movement. And I think what this data is telling us, or one thing that we can take from this data, is that to care for the sentience of these animals is to have to incorporate broader concerns about the environment, such as habitat protection, into our quiver of tools. Interestingly, a recent study by a scientist in Australia establishes a methodology, so a scientific methodology for assessing the mental and psychological well-being and reactions to different environmental stressors of wild animals. And so science is moving in the direction as well of being able to calculate kind of what we instinctually know about these animals. Of course, they're struggling to feed a family, walking or having to fly longer distances to find water, to find habitat, suffering the inability to find shelter, to find places to reproduce, to care for your offspring or your young. All of that impacts the well-being of wild animals. And so to be cognizant of that, right, we need to also care about environmental concerns like plastic pollution, toxics, mining, deforestation, and all of these activities that are typically within the environmental wheelhouse. It works in the reverse too, right? So livestock production for grazing and feedstock is the single largest driver of all of the habitat loss we're talking about. One of the points that the IPBES report makes is that the projected land base required by 2050, so like in a pretty short time frame, to support livestock production in several what we call mega diverse countries exceeds by 30 to 50% their current agricultural area. So we're talking about in a business as usual trajectory, massive amounts of land conversion. If we don't, both as environmentalists, consider changing our diets and relying less on meat, and as animal activists, considering being environmentalists as well. And so it sort of crystallizes, that the time is now to kind of like de-silo a little bit, and use all practical tools that we might have in our belt, to make progress on behalf of wild animals. And that's kind of what we're here talking about, with us as practicing lawyers, looking at every opportunity that we might have for thinking about, how are we going to, from an organizational perspective, like have a legacy of protecting animals, and what are the things that we can do. So of course, in the background is climate change, maybe not even background, at the forefront. We need to add it to the mix as we consider all of the impacts on wild animals. It makes everything, as we all know, ever more bleak for both humans and non-human animals. There's absolutely no question that climate change is exacerbating and reinforcing other drivers of biodiversity loss, and environmental and other habitat related degradation. So if temperatures continue to rise above the 1.5 degree threshold and creep toward a 4 degree Celsius increase in warming, there are multiple regions, and this is what this graphic here is showing, across both the marine environment and the terrestrial environment, that risk becoming inhospitable to up to 100% of the plants and animals living there. So like total devastation in those particular regions, short of causing death or more broadly extinction. Climate change is impacting the expression of sentience of wild animals on a daily basis. It is increasing the time needed or distance traveled to access subsistence resources for wildlife. It's shifting habitable ranges for species. It's shifting forests and grazing lands that species and animals use. It's damaging ecosystems that provide, of course, ecosystem services to humans. We commodify ecosystems to think about benefits to humans. Oftentimes we fail to put into that calculus the benefit to wild animals, but it's all impacting animals just like it's impacting us. And here are just some examples where we can talk about wild animals that are already negatively impacted by warming temperatures, including extreme heat, flooding, coral bleaching. These are all already pushing species closer toward extinction. Arctic sea ice is melting, and ice-dependent animals are more susceptible, are struggling to feed and take shelter. This beluga, for example, relies on feeding on schools of fish that swarm under ice. Without the ice, it's harder to find the fish. Other studies have shown that species like African wild dogs are more susceptible to disease and are dying at higher rates in warmer climates and in drier climates. Animals like seabirds, like these penguins, are having a harder time reproducing and feeding their chicks. The cycles of their reproduction are off, meaning it's colliding in ways dangerous to their chicks with seasonal changes, and the rates at which those seasonal changes are being modified by global warming. In the face of all of this, right? So we have these twin sort of existential, and maybe not even existential, it's actually probably the wrong word to use here, because they're very, very real. They're not just sort of like possibilities, but these twin crises. We have this biodiversity crisis, we have this climate change crisis. And what the IPBES report is telling us is that in the face of these, we need transformational change in the indirect drivers of those biodiversity impacts. So if you indulge me, I'm just going to go back really quickly to this first slide, and you can see here that what IPBES is showing us in this graphic is that these indirect drivers, demographic and sociocultural drivers, economic and technological drivers, institutions and governance drivers, and conflicts and epidemics, we need to fundamentally transform the way that we think about how, as a society, we are doing those things and managing with respect to those indirect drivers. And it's only at that like root base that we are ever going to address and pull back the impact that we're having on biodiversity, on wild animals. So for the purposes of this talk, because what we want to do is get to a place where we can talk about the rights of nature and how it is potentially a promising legal framework in the context of all of this, we need to kind of look and examine what it is we're trying to transform from a legal perspective. So looking, probably primarily at the sort of economic drivers, and then the institutional and governance indirect drivers of all of these twin crises, and in particular here, the biodiversity crisis. So from an institutional and governance perspective, the goal of what we've been calling for the last 35, 40 years sustainable development is the framework that we have been operating under. It's the sort of mantra that has driven and sort of focused how we manage our relationship with nature, humans' relationship with nature. So since the 60s and 70s, fully 40, 60 years ago, humans have understood that to continue making our world a home, we need to rethink our habits and patterns, which was critical at the time. That understanding and that awakening and the ability to internationally recognize that launched not just this like global reimagining of how we interact with the world, but it also spawned environmental initiatives and new environmental laws around the world. So at the time, it was really this sort of brand new and, very ground shifting paradigm to operate under. In the 70s, in 1972 is probably when this sort of like paradigm really kicked off at the UN Conference on the Human Environment, where the goal of that conference was to institute a conversation between developed and developing countries about economic growth, as well as the health of air, water, and land, and the well-being of people, with the environment at the forefront of those conversations. And I want to come back to that framing, but, just to make the point here is very much about what people need. Knowing that like we were putting ourselves in a moment of crisis because of the way we were exploiting the environment. Eventually, by 1987, as the sort of themes around that continued to be explored, continued to be enshrined in different international documents, continued to be worked on by the international community and implemented domestically, in a commission led by Gro Brundtland, at the time Prime Minister of Norway, put together a report that's called formally Our Common Future. It's also known as the Brundtland Report. But that report really sort of memorialized this term sustainable development and captured in this like single concept all the thinking that had been going on in terms of this international movement around, considering the environment as a priority in development goals. The report defines sustainable development as the development that meets the needs of the present without compromising the ability of future generations to meet their own needs. And so, this idea of sustainable development, maybe if I could just make like 3 points about it, which is barely enough to cover, sort of to unpack the concept, in its entirety. And it's not the goal of this talk or CLE in the first place. Entire books and courses are hardly enough to interrogate it. But 3 main points here that I think are central for our thinking. One, I think we need to acknowledge even, that the framework failed to account for a huge number of things, including many of the indirect drivers of environmental destruction and other externalities and inequalities associated with the economic models, based on capitalism, right? It's sort of locked in colonial growth patterns, the influence of international financial institutions in exploiting people and natural resources, particularly as debt service. There are all these sort of consequences of the economic model, but also, failure to consider the indirect drivers generally of the consequences to the environment at the time that people were taking cognizance of. At the same time, I also think it's important to, recognize that at the time it was more than what had been put on the international agenda, right? All of a sudden the environment was on the international agenda, and that, we can't sort of write that out of history. It was a hugely important step, toward a better growth model, if not perfect growth model. And so it was making sure that we were, as an international community, as imperfectly as it was done, thinking about the environment as part of the development calculus. And, I mentioned this before, but it definitely ushered in a new era of environmental legal development, around environmental impact assessments, wildlife protection laws, the establishment of protected areas, all of which, again, are not perfect, but that we didn't have before, that weren't sort of restricting, cabining, managing human interactions with the environment before. The third thing that I want to say, though, and it's, I've basically already said it, but like we can agree that even if it was a sort of new paradigm that shifted the way we were thinking, in the face of these crises that we're currently operating with, the biodiversity crisis, the climate change crisis, it is a wholly insufficient governance or institutional or legal or economic model to keep human meddling in the environment and human behavior adequately at bay to give both animals and the environment the space and agency and autonomy it needs, or, you know, the it and they need to survive. So the question then is, what do we, you know, what are we looking for in terms of a transformative or transformational approach to legal frameworks? And I think here we need to think about in a little bit more detail sort of what the existing legal framework has been that sort of articulates with the sustainable development framework, or, you know, the legal framework that has been operating under this sort of sustainable development goal that we have as an international community. And the way I like to look at it that I think is helpful is to sort of to start with, what are the barriers in terms of this model achieving the transformational change that the IPBES report calls for? The first thing, as you can see here, is that it situates people and people's needs as the motivational force of the law and of the sustainable development framework. So the goal, right, what we're trying to achieve is that we don't abuse the world too much, that we constrain our impulses, our instincts, and our choices just enough that we can say we took the environment into account, because we understand, like in the Brundtland report, that if we don't, our children and our children's children won't realize the same benefits of exploitation as we currently do. So the legal model that we currently, that most of us operate under, or many of us operate under, is this, where we have rights holders, and then we have beneficiaries, or what we hope are beneficiaries of the way that humans and now corporations with legal personality exercise those rights. You know, and the beneficiary element of it, we have all these new laws that are, you know, since the early 70s supposed to be beneficial to wildlife, to the environment, to our waters. But it's all based on this balancing act where humans are the rights holders, and where humans are the focus of the law in terms of really the goals of the law, right? So I think probably, in fact, we could say that maybe at best the environment and wildlife are co-beneficiaries. And what this means is that most of the laws that we have, particularly here in the US, there are these like risk-based calculations that are built into the laws, and those risk calculations, right, just inherently are more comfortable with deterioration, degradation, harm to the environment or wildlife, because it's all based on foreseeability and likelihoods that are rooted in what we call best available science. Not to say that those calculations and the implementation and enforcement of all of those laws haven't greatly benefited the environment. I think the point here is it enough against where we stand today? And is this a moment or an opportunity where we need to think about whether the structure and the formulation and the nature of those laws gets us to where we need to be if we're genuinely taking wildlife, animals, and the environment into account, and being real about what transformational change looks like. So how do we put wildlife and the environment back into, or just into in the first place, the balancing act that our current legal system strikes? and ultimately we need a new way of thinking about our relationship with nature, and we need a new way of thinking about how law mitigates that relationship and the goals that the law is attempting to achieve. And I think this is where a rights of nature and other rights-based concepts can come in. If we're moving from this sustainable development model to what a lot of folks are talking about, to a more One Health mode of thinking, where the interrelatedness of humans, animals, and the environment is recognized, and where there is in the model built in more parity in terms of the legal goals. For example, if we're applying it to legal frameworks between humans and animals and the environment, you know, it represents moving from this strictly anthropocentric perspective to a more holistic perspective that recognizes wildlife, animals, and the environment as stakeholders in their own right. Right. So from a legal perspective, it means that each should be on a more co-equal footing. And that should shift the balance such that, you know, the goals of our institutions, governance models, our laws are supporting that parity. And it might mean, as we're going to talk about, that nature, that wildlife, that the environment should be rights holders just like humans are. And it's interesting, you know, thinking about One Health and what it means, and then thinking about and what it should mean, what it could mean in terms of being a transformational way of thinking about how we manage ourselves as humans. Looking at, for example, the Endangered Species Act, or internationally for folks, the Convention on International Trade in Endangered Species, the Convention on Biological Diversity, most local or, you know, domestic environmental or wildlife legislation all enshrines notions of sustainability, with the goal of sustainability being long-term outcomes for humans. You know, not sustainability from the wildlife's perspective, not sustainability from a particular river's perspective or nature's perspective. And so when that human-focused sustainability is the goal, whether we're talking about like direct consumption, ecosystem services, or other commodified benefits, we're sort of building in an imbalance. And with those current laws, even if we do our damnedest to be as progressive as we can be in the implementation and execution and enforcement of those laws, there's just a baked-in imbalance that I think we would argue just is not transformative unless we have something, we're adding something to the mix that recalculates that balance. And this is where the rights-based approach and rights of nature has the potential to be that rebalancing, to be that transformation, because it puts the wild animals or nature in the position of defining the needs and goals of the law and of decision making and of institutions and governance and our economic models. The laws themselves, the implementation and enforcement, should be designed and executed with the question in mind: what does nature need? What does a particular wild animal need to thrive? And how do we humans modify our behaviors and expectations in order to meet those goals? You know, and I think as Nick is going to discuss and take over the conversation now, we can see that there's a clear toehold in the law for rights of nature approaches, and that those approaches are from our perspective, really helpfully evolving from a strictly ecocentric ethos to also applying to individual wild animals and the species as a whole. So, and I think as Nick will get to, like, even though it's not a perfect solution, it's not going to fix the biodiversity crisis. It can't bear that on its shoulders. It's not going to fix the climate change crisis, obviously. What it does do is give us potentially some practical tools that we can rely on as practicing lawyers to use the law to protect wild animals and move us toward this transformational shift in how we think about how we should be engaging with nature and what that means for institutions and our governance models and our laws. So with that, I'm going to pass it over to Nick.
Thanks, Erica. That was a great presentation, populating sort of the important landscape here in terms of our kind of core ideas. And I like your term of rights of nature, maybe having gained a toehold, and I just take that one step further and say, you know, maybe it's a paw hold or a claw hold or a beak hold as well, as we'll see. So to ground our presentation a bit more here, we thought we would share some brief remarks on how different jurisdictions have actually implemented rights of nature, or better put, are implementing, right? This is an ongoing process we're witnessing in real time. Our remarks are both descriptive and normative. So in addition to telling a few stories about how some different countries have approached the matter, we will offer select thoughts on how these approaches advance the interests of nature with a particular focus on wild animals. And rather than keeping to a strictly chronological order, which, you know, is available if you want to check out some different sources online, for instance, we thought we would try to break down a few of the more important implementation efforts by kind. And so with that in mind, we first up have a constitutional approach, which perhaps is the most obvious way to enshrine and elevate legal rights of any kind. And Ecuador is a great example of that approach. Then we have a statutory approach, and here we'll use Panama as illustrative. And then finally, and of course these are not mutually exclusive, we have a judicial approach, which you could, you know, think of as well as sort of a common law approach to building out the law, depending upon the particulars of the country. And Colombia, in this case, we'll focus on as an example. So we can advance to the next slide and take a look now at our first approach, or the constitutional approach. And we'll just get right into Ecuador's history here. So in 2008, Ecuador adopted a new constitution that marked a significant break, a significant change from the previous constitution. It wasn't just, you know, an amendment here or there. It was and is considered progressive in many ways, not to say perfect. Among other features, the Constitution includes, I should say, several articles enshrining explicitly the rights of nature, and importantly, creating a basic mechanism for citizen enforcement to supplement government enforcement of this right in the case of a violation. So just to really get as concrete as possible, I want to just quote briefly some of the more salient language. So Article 71 reads as follow in part. Nature, or Pachamama, where life is reproduced and occurs, has the right to integral respect for its existence and for the maintenance and regeneration of its life cycles, structure, functions, and evolutionary processes. Goes on to say, and this is the enforcement point, the sort of citizen enforcement point, all persons, communities, peoples, and nations can call upon public authorities to enforce the rights of nature. To enforce and interpret these rights, the principles set forth in the Constitution shall be observed. To translate that, it's kind of a mouthful, and of course, in Spanish, its intent is a little bit clear. But people, including organizations, if they believe that nature's rights, right, not their rights, for instance, or the rights of community members, but nature's rights, right, non-human rights, have been violated, they can bring an action demanding a response by the government. And so that's a way to force the issue in court, right, concretely speaking. Article 72 talks a little bit about the content of these rights. We'll get into this more in a bit. Article 72 says nature has the right to be restored, right? So it's not just sort of, okay, nature has a right to be free of harmful action, but to the extent it's suffered harmful action already, it actually has an affirmative right to some sort of help, to some sort of restoration. And the restoration shall be apart from the obligation of the state and natural persons or legal entities to compensate individuals and communities that depend on affected natural systems. So again, this idea of, yeah, people can be affected by harms to ecosystems, for instance, but also nature, and also wild animals within nature can be affected as well. And we're going to recognize that the two kind of can be victims here, right? It's not just, oh, we've satisfied human needs, we've responded to the human harms, case closed. No, there's another line of attention. Now, while this language, I think so far sounds great, depending upon your perspective, sounds hopeful, there were some initial worries that it might have just sort of being merely auditory for lack of application in particular situations, particularly through the courts, right? Are we going to actually get enforcement actions that are going to be entertained seriously by courts, producing judicial orders of relief that are meaningful? That was a real question. I think it was a valid question. But looking back over the past several years, we can confidently say, and frankly, a pretty quick Google search will confirm this, that there really is a full body of case law now in Ecuador interpreting and applying this framework in specific cases, from proposed mining projects that have been scuttled in certain cases to our topic, recently a case involving a single brown woolly monkey. So that's what I would say on, or what we would say on this example so far of the constitutional approach. Next, we'll take a look at Panama on the statutory approach. Now, of course, lawyers, we all know, while enshrining rights at the constitutional level can provide certain unique benefits, procedural and substantive, of being able to claim protection under the supreme law of the land. The constitutional approach isn't always the only pathway to achieve legal change, and in this case, to implement rights of nature. In many scenarios, a statute, or perhaps a statute accompanied by implementing regulations, will be more feasible and still move the needle. So Panama is a great example here. So in 2022, so quite recently, Panama adopted a general rights of nature law that just went into effect a couple months ago. The content of the law tracks many of the basic contours of Ecuador's constitutional provisions that I just cited. So just briefly to highlight a couple of things, the law requires the state and all persons, whether natural or legal, so corporations, to respect, and protect nature's rights. Those rights enumerated to include the right to exist, persist, and regenerate life cycles, and nature's right to timely and effective restoration. So again, that idea as well. And on the enforcement front, similar to what we saw in Ecuador, it's not simply left in the hands of the government. The law also contemplates effectively a citizen suit provision, not to our knowledge with attorney fee shifting provisos. So that particular feature isn't there to our knowledge, but it does contemplate that, hey, citizens and not just the government can bring actions to vindicate these rights. Another detail I wanted to mention that I think is kind of interesting in Panama's rights of nature law is there's some new practical elements, like a provision installing what's called the in dubio pro natura principle. This principle, I think to many in the audience might be new. It's grown a lot in the Latin American region. But basically what it means, it's effectively a canon of statutory construction. It means that in cases of ambiguity or conflict between laws, the interpreting court should err on the side of a reading more favorable to nature. So kind of cool, certainly not limited in its application to just rights of nature laws, but in the vein or in the argument, I think Eric and I are trying to advance here that, hey, these laws actually are, yes, informed by some loftier thinking, but at the same time, practically or can be practically tailored, right, with really specific application, right, on the ground in courts in mind. So that's another example, I think, where the law is doing that. Now, there's more. You might wonder, why the sea turtle here? Well, building on this general rights of nature law, Panama recently passed a supplementary law specifically focused on sea turtles. Among other features, the law recognizes sea turtles' rights, right? So now we're not just saying nature. You might wonder, what is that? What are the bounds? Sea turtles' rights to live, have free passage in a healthy environment, I'm quoting now, free of pollution and other anthropocentric impacts that cause physical or health damage, like climate change, pollution, incidental capture, coastal developments, and unregulated tourism, among others. You might say, well, again, that's nice sounding, but is it just a declaration of rights and that's it? Well, no, it's not simply declaratory. The law is also explicit about the implications for irresponsible developers, irresponsible tourism operators, and others in sea turtle habitat. It instructs agencies to cancel operating permits in certain cases. So it's certainly not just, okay, there are these rights. There are also provisions around when does a violation occur and what are the consequences. Now, should say, because this law is so new, the sea turtle law, we're unaware of any enforcement efforts to date. That doesn't mean they're not happening. It's just come in, I think, 2 months ago. But it is interesting to see that through this statutory approach, Panama has confronted the question, well, can wild animals take protection or be the recipients of the rights of nature framework, and answer that question explicitly, yes, right? At least for sea turtles, and hopefully building out from there. So we'll take a quick look here at another case. I'll keep my remarks here shorter. Ecuador and Panama, again, have been very sort of deliberate and explicit, making decisions at the highest levels of government to adopt rights of nature, and in the case of Panama, right, explicitly extend them to sea turtles in statute. There's also some jurisdictions, several, that are seeing the emergence of rights of nature through courts, right, through judicial decisions. And this has notably occurred in India, Pakistan, and Colombia. So Colombia, as an example, Colombia's constitution, current constitution, dates from 1994. a lot newer than other constitutions, but at the same time, before rights of nature was really starting to gain traction in law, at least. Doesn't mention the rights of nature, right? Again, in keeping essentially with its date of adoption. Nevertheless, in a 2016 case involving this river that you can see, both pictures are the same river, the Atrato River in Colombia. In a 2016 case involving rampant illegal mining and deforestation throughout this watershed, Colombia's constitutional court held that this riverine ecosystem has rights, and that those rights had been violated through a combination of private illegal action, i.e. illegal miners and illegal loggers, and governmental omission or complacence, right? The government knew it was happening and just hadn't been doing much to stop it. Among other rationales in arriving at the idea that, hey, this river has rights, essentially, we think the rights of nature provision applies, or I shouldn't say provision, framing applies. The court here pointed to the Colombian Constitution's articles on the right to a healthy environment, because the Constitution does in Colombia say, hey, there is a right to a healthy environment, and implied, and I want to be careful here, implied that, this is my interpretation a bit of what the court was doing, implied that this right to a healthy environment may not run simply to humans, right, but also to others, aka nature, and whatever may sort of make up nature. So there's a right to a healthy environment. Normally we think of, oh, well, humans have a right to a healthy environment, but what about a river's right to a healthy environment? So ultimately, the Colombian Constitutional Court got there, despite there not being, a clear constitutional provision or statute on the matter. Now we will get to the last slide for me, and I want to just kind of ask a few fundamental questions. You can see them here on your screen, and along the way, hopefully begin to identify some objections or critiques of the rights of nature movement, and hopefully begin to respond or offer rejoinders to those objections. So, regardless of the approach, constitutional, statutory, judicial, any real implementation of rights of nature needs to answer a few questions. First, rights to what, right? If nature has rights, what are those rights? I think we've kind of covered this along the way, but that's an important question, right? Second, if nature has rights, how are those rights vindicated or enforced? Again, we've offered a couple examples, but I want to drill just a little bit deeper. And then insofar as wild animals are concerned, right, what's in it for them, right? What's the added value of rights of nature for them, as opposed to just, hey, we got good or decent, environmental laws, and hey, we have, animal law, which is doing its thing. What might be the added value of rights of nature in particular for wild animals? So on the first question, again, I don't want to spend too much time, just because I think we've already offered a couple of examples of the rights that nature has in a lot of these framings. But to recap, most rights of nature provisions or descriptions in judicial decisions say that nature, however defined, it's kind of a separate question, has a right to existence, to be respected, and to restoration. I want to really shorthand this as essentially nature has a right to be nature. Nature has a right to be itself, right? That's essentially what we're about. And again, to echo Erica's points, or to go back there, that's radically ecocentric, even though it might seem subtle at first, right? It's not, okay, what level of protection do we need to afford to the environment or animals such that humans can thrive. Well, no, nature has a right to be itself. What's that entail, right? What does that imply? The second question, going to enforcement, also points to one of the main critiques that we hear and that's out there, and it's there should be a conversation about this. And that's, hey, this is all just nice sounding language. I don't see how it can really be enforced, or to the extent it can be enforced. Hey, other existing laws can be enforced as well. How's this really moving the needle or adding anything on the ground? We disagree with that critique, even though we acknowledge it as being one that requires a response. So just first, I would say, well, let's look at some case examples, right? Look at Ecuador and Panama. We have provisions there contemplating citizen petitions denouncing violations of the rights of nature, requesting judicial relief. And in the case of Ecuador, which has a longer history, many cases where that happens, and there actually are outcomes in favorable of those petitions, right? So it's as simple as a law including an enforcement provision. And then, yes, we need court systems. We need, motivated and significantly independent actors to do their thing. But as a matter of legal design, it's hardly tough to pull off. Now, I think the other thing to think about creatively is what else might you do with the rights of nature framing to make it even more effective on the ground? Well, maybe you don't want to wait for a plaintiff, right? And maybe you also feel like the Department of Justice equivalent in any country, we're not sure we can totally count on them. Well, countries could create rights of nature ombudsperson offices, similar to the approach taken by many countries vis-a-vis human rights, right? There's some experience from the human rights saga that we can draw upon. In terms of remedies in the event of a violation, of course, you can have injunctive relief, monetary fines, restitution orders, and even criminal penalties, right? The Colombian court's decision in the Atrato River case also shows that courts are capable of crafting unique remedies that really reflect the ecocentric character of this rights of nature doctrine. I'm going to say a lot of detail here in a second because I just want to unpack a little bit what the court's remedy was, but I think it's worth it to get our imaginations going. So in that case, again, involving illegal mining, deforestation, and apparent government complacency and failure to respond or to control that, the court ordered the government first to choose a body to serve alongside representatives of the local indigenous communities as the legal representative of the rights of the river. So yes, we have to, so far anyway, use humans as intermediaries, right? But we were going to have a legal representative comprised of a diverse group of stakeholders to represent those rights. Second, the government was ordered to form a commission of guardians that included government and community representatives, as well as others, with the task of ensuring protection, recovery, and due conservation of the river. Also, the government was ordered to develop an action plan to eliminate illegal mining, right? So sort of that action forcing, hey, you got to come up with a plan. Again, similar to creative injunctive remedies we're used to seeing in federal court. And also the government finally was ordered to design and implement a plan to decontaminate the watershed, go into that restoration idea, recover the ecosystems, and avoid additional damage through measures such as reestablishing ecological flow, so increasing the flow of water, eliminating sediment buildups, and so forth. If we trust courts to get creative, when there are broad-ranging violations of the law in other areas of this society of ours in different countries, they can do it in these cases as well. But the rights of nature framing says, hey, approach this, right? Not from the needs of people, again, but from the needs of nature. What does nature need? And last but not least, we have this question, well, insofar as wild animals are concerned, insofar as wild animals are concerned, what's the added value for them? Maybe you're convinced, I hope, that ecosystems at least stand to benefit from this doctrine when well implemented. But you might still say, but I'm not sure about the animals that live in those ecosystems. Well, Eric has already talked about how, indirectly at least, if we do a better job protecting habitat, caring for habitat, animals benefit from that, and in fact need that, right? But more directly, as we saw, Panama shows how a general rights of nature law can be supplemented by a more specific law focused on wild animals. So there's just one very obvious way to do it, right? Have another law that essentially extends the principle to wild animals. Also, to go back to our, evergreen option of decisional law, in Ecuador, in a famous case in 2022 involving a brown woolly monkey, Ecuador asked the question, well, under our constitution, which talks about nature and its rights, does the definition of nature actually expand to include wild animals, such that wild animals can also say, hey, we are rights holders, right? It's not just the riverine ecosystem or, the jungle writ large, but wild animals in particular. And the court in that case said, yes. Wild animals also have rights as part and parcel of nature. And specifically, and I'm not going to rattle off the court's decision here, but I want to highlight a couple of things. The court said wild animals have the right to exist. They have the right to free development of their animal behavior. And all that entails reproduction, social activity, being able to access food, etc. They have the right to freedom and good living. They have the right to food, again, as I mentioned, according to the species' nutritional requirements. Right to a habitat. There we go. They have a right to a habitat. And right to live in an environment that is suitable for each species. I think that, again, goes back to the idea that, hey, well, if there's a right to a healthy environment, and that's in the international community and in many countries much more terra firma, maybe the right to a healthy environment is also a right held not just by humans, right, but also wild animals, and we could go beyond that. To conclude my part, at least, yes, the application of rights of nature writ large, and then even more specifically to wild animals, is still, in its infancy, but the road ahead looks promising.
Thanks, Nick. Thanks for sharing all of that wisdom about those cases and the different approaches where we see rights of nature, and then specifically within that framework, wild animals as rights holders. I hope that folks are inspired by this talk. I think we're having a conversation that on one hand is pretty meta, on the other hand is a little bit more specific, where we've started to see this claw hold in the law for rights of nature, and then specifically again, the case law that and the statutory law in Panama that's showing us specifically that wild animals themselves are rights holders or can be rights holders in that framework, and not just to sort of have habitat, but to fully express their sentience and to have their well-being cared for. And so, to me, that is a transformational perspective on how we have historically governed our relationship with nature and our relationship with animals. And it holds promise. And so, like we're always telling our students, maybe I'll just end with this. because we do, get a lot of some doom and gloom in the classroom in the face of all of these things. And I think that as practicing lawyers, as academics, there's still room on the table for new ideas and innovative approaches, and humans have the ability to sort of make the kind of transformative change that IPBES and sort of other institutions are telling us, and that we know in our hearts that I think we need in terms of the law. So thank you for CALS for supporting us and for allowing us to give these talks and do these CLEs. It's always a lot of fun.